Let's say you're walking home one night on your phone and somebody steps out, waves a knife and says, "Oi, hand over that phone." So you do. But as luck would have it, you recognise the person and you know where they live, so you tell the police. The police go around to the person's house and they say, "Oi, you've just been accused of robbing somebody of their mobile phone." And the guy says, "Well, I don't know what you're talking about. You know, search, there's nothing here." And they can't find a phone. Or they do find the phone and he says, "Well, yeah, but the guy sold it to me. Or he gave it to me because he wants a new one." Can there be a prosecution on the back of that? Well, what's the evidence that a crime was committed? The evidence is that you saw it and you can give testimony to that effect. And this is something that happens all the time. And the reason I want to talk about this is, we do see this a lot in relation to certain types of offences that I won't say because it'll trigger the algorithm. But people say, well, what's the evidence? How can you convict somebody with no evidence? It's just their word against somebody else's. But their word is evidence. Okay? Now, when the CPS decide to charge somebody, there's a two-part test. There has to be a realistic prospect of a conviction, and it has to be in the public interest to prosecute. What's realistic prospect of conviction? Well, just that there is enough evidence that a jury could convict. And if a jury believe the victim stroke complainant, well, that's all that is necessary. What's the public interest? Well, that is, yes, okay, sometimes you can say, like, there is enough evidence to show a crime has been committed, but in the grand scheme of things, it's not in the public interest to prosecute. It could be because, it's a relatively minor offence and, the offender is a juvenile or something like that, or there's some other extenuating circumstances. Obviously, the more serious the crime, the more likely it is to be in the public interest to prosecute. However, the mere fact that there's a strong public interest doesn't negate the first test, that there must be a realistic prospect of conviction. But the reason I'm mentioning this is we see this a lot in relation to certain types of offending that I won't say because, it'll trigger the algorithm. But people say, well, it's just, their word against somebody else's. How can you possibly convict? What's the evidence? Can somebody be sent to prison just on the word of one person? Well, in relation to most offences, yes. There is no requirement in English law, but, see Scottish law for a comparison, for there to be what we call corroboration. That is to say, some other evidence than merely the victim saying that it's happened. There are a couple of exceptions to that. Treason is one. Perjury is another. You can't convict somebody of perjury without at least two bits of evidence showing that the statement in court was false, or the statement in, a statement where you swear that it's true, because that can also amount to perjury. Also, in relation to some speeding offences, there needs to be more than just one piece of evidence. So if a police officer says, "I saw you and I reckon you were speeding," they have to say, "and also I checked the speedometer and I was following the person and I was going fast and, I wasn't catching up with them." So, but they generally are now the only offences where you actually require corroboration. That wasn't always the case, though. And I think it's interesting that sometimes this, why should we believe her? That seems to be like the attitude for so long. And it used to be that complaints about these particular sorts of offences did require corroboration. You couldn't just take the victim's word for it. And that wasn't actually abolished until 1994. But yeah, that is the position now. And I just thought it was worth mentioning, you see, because like I say, people keep saying, well, where's the evidence? But witness testimony is evidence. It's a very common form of evidence. And people are convicted on the word of one witness all the time for all sorts of offences. So there's nothing particularly unusual about just one witness sort of, cases about these sorts of offences. Now, of course, we do get into the issues, and I've done other videos about this, about how hard it can be to convict in those situations, because, of course, we have to prove the offence so that the jury is sure. And if it is one person's word against another, even if the jury is highly suspicious, even if they think this person almost certainly did it or is very likely to do it, that is not enough. They have to be sure that the person that did it. But the mere fact that juries can be reluctant to acquit doesn't negate the realistic prospect of conviction test, because, you know, the conviction rate in these sorts of offences is actually about 72%, which is on a par with the conviction rate generally in the Crown Court. But yeah, I just thought that was worth mentioning because it's something that sort of, you know, crops up a lot. But anyway, if you found that useful, and I always feel a bit weird sort of, you know, asking to like and subscribe, and, you know, when I'm referring to things like this, but if you did find it handy or useful, or just something that you can use to rebut other people when they raise this point, yeah, please consider doing so.